What's happening, fighters? Here we are, Gloves Off Podcast, episode 25, Governmental Immunity Protecting the Guilty. We have an incredible panel, and back with us after all the letters that you all sent and emails, thanking Judge Amy Ronayne Krause for joining us last time. We had to bring you back.
Oh, thank you.
So thanks for being here. Chris Desmond, of course, our chief appellate attorney, and the incomparable Paul Doherty, my partner and managing partner in Detroit office. So guys, last time we were talking quite a bit about governmental immunity, and we talked about like the notice requirement. So let's get even further in the weeds, as we say, and talk about the number one thing that for plaintiff lawyers on behalf of injury victims that we face that make it so difficult to even get to trial is are the requirements of gross negligence and the proximate cause. So Chris, explain to the folks, if you will, if we weren't talking about governmental immunity and we have to prove at the time of trial, what are those, what's the difference between what I just talked about, gross negligence and the proximate cause?
Well, so if you're dealing with a private tortfeasor, not a public entity, a governmental actor, we can show ordinary negligence, which just means someone failed to act with reasonable care. And we have to show that you were a proximate cause, that because of your negligence, I suffered some injury. And it might not just be because of your negligence. There could have been 6 negligent actors. And a jury gets to look at those six actors and say which percentage of fault each actor is responsible for. With governmental immunity, you have to show that they were the proximate cause, which the courts have told us means the one most immediate, efficient, and direct cause of the client's injuries.
And then how about
gross negligence? Which gross negligence, so there's a statutory definition in the Governmental Tort Liability Act that essentially shows that you showed substantial disregard for the possibility that injury could occur. I think the case law actually treats it even higher than that statutory language does. It's almost akin to willfulness. If it's
borderline
greater than recklessness, yes, you have to have very egregious conduct to be confident that you'll have a finding of gross negligence.
Which I find, because I talk about this in my voir dire and when we do mock trials and with jurors and just people in general. When people, the average Jane and Joe, hear about gross negligence, Amy, I don't think they think that it means like basically intentional misconduct.
I don't think that either. I think that most people believe gross negligence is not what the statutory definition is.
Right.
The statutory definition is very, very strict. It is, as you said, it is really a very strong standard, and it's almost, quite frankly, it's almost an impossible standard to meet.
And what's happening, folks, when we talk about government immunity, we're now going to kind of let's give the real life example of the Oxford tragedy in the Oxford shooting case, because what's in the news right now, of course, is Oxford and this case and the civil case that we're involved in. And the defendants, Chris, the Oxford Community School defendants, and we'll get even a little bit more into the weeds and explain who they all are. They are asserting, Johnson, you can't prove that the teacher or the principal or whomever that we're suing was grossly negligent. You might be able to prove that they're negligent, but you can't prove that they're grossly negligent. And even if you can, the proximate cause is Ethan Crumley and his gun. So they've already filed those motions, Chris. Tell them.
That's right. Yeah, they've filed those motions. And so they're, it's funny, and I've said this in court several times. I've maybe said it in front of Judge Krause before. It's always interesting. You never get defendants admitting negligence in the Court of Appeals unless they're a governmental actor. Then they're very quick to say, well, yeah, we were negligent here. We just weren't grossly negligent, right, so it doesn't matter.
Right.
That's sort of what's happening here. They're saying that, well, even if there were mistakes made, they don't rise to the level of gross negligence. This is just ordinary negligence, so it's not enough.
So in perfect example, in Oxford, one of the teachers that I took the depositions of, who saw on Monday, the 29th of November, 2021, saw Ethan Crumley on his phone when he shouldn't have been on his phone, looking at bullets. Okay. Now, she then reported that ultimately, not at the time, but ultimately reported that to a counselor and also reported it to basically the dean of students, that I'm going to call an assistant vice principal type guy. So the guy that was responsible for counseling kids and the guy who's responsible for disciplining kids if necessary. So she reported that, and they're going to come in and say, and they already are in their motions, and said, okay, that may be negligent, but it's not gross negligent. But then we have that same teacher later on that day going back and looking at Crumley's earlier paperwork from earlier in the year, and she found a drawing, not the drawing that everyone saw back in the day from a math paper. This is a drawing that he did one of the first days of school, where he drew himself with a gun pointed out straight ahead at someone. And it was a handgun, right? Just like the one that he ultimately had and used. And she then claims that she gave it to the counselor, but she forgot to give it to the disciplinarian, the assistant principal. So our argument is, guys, and I think most lay people, in other words, non-lawyers, and maybe lawyers too, would say, yeah, that one looking on the phone, if she should have done more than that, that's negligent. But when you have a drawing of a handgun in a school with all that's been going on, Paul, that's gross negligence.
Well, with a kid like that, with all the other signs and symptoms that he was exhibiting, is it substantially likely? That's
where they're going to go.
Now, why doesn't a jury get to make that call?
And I absolutely, Amy. So here we are. The defendant's down, and we're just going to stick on. And this example, by the way, goes all the way down. So we've sued, of course, not just that teacher, another teacher or two. We sued the counselor. We sued the assistant principal, etc. So, but it's the same type of an analysis per individual. Why not just let that case go to the jury and let the jury make the determination whether that's negligent, gross negligence, or nothing at all?
Well, what I'll say about that is I think that the case law, where I think the biggest problem is, just so you know what I think, is the vicarious liability issue. That's where I think the biggest problem comes in, is that how are they liable for what he did? And that's where I think the biggest problem lies in the case law for you.
Here's what's interesting, guys.
And I'm not saying that's right or wrong.
No, I hear
I'm
you.
just saying that's the law.
I agree with you.
Yeah.
And this is why from the beginning of this case, when our firm was fortunate enough to be involved,
right,
you're looking at the Brain Trust and had Tom Wan and a couple of other of our attorneys.
Right.
And we said, we need to take on governmental immunity in full in this case. Because if this very thing, ladies and gentlemen, sorry that I'm repeating myself, if this very thing happened at a private school, God forbid, we would not be talking about this nonsense, because it's just the straight negligence standard and a proximate cause, just like Chris described.
Right.
But because it's at a public school, which, by the way, our children are legally required by our government to go to school. And if you don't, you can go to a private school if you want, but if you don't, you have to go to a public school.
Well, and you have to be able to afford the private school.
Agreed. But my point is this is a government-run process.
Exactly.
And you're going to fucking give them a break and say, if they absolutely ignore what a same teacher in a private school, if that teacher would have, we'd have already settled this case by now, Amy, if this was at a private school. But what's important for everybody to understand is when we go and argue those motions, which, by the way, are now going to be argued on February 1. So we got an order last night, unfortunately, from Judge Brennan denying our motion for more discovery and denying our motion to move that hearing back. But hey, here we go. So when we go argue that, the Oxford defendants are going to say that this is not a single one of these people committed gross negligence, because the standard is so high, just like Amy and Chris were talking about. Judge, you should throw this case out of court as a matter of law. Translation, not go to trial. And oh, by the way, even if you find one or a couple of these people were potentially grossly negligent, or at least to the point where the jury needs to make that call, since Crumley was the most immediate cause of these injuries, that gets thrown out too. And Chris, what is the if she says that in whole, what does that mean? What happens then?
Well, I mean, if she adopts their arguments in whole, then we're up in the Court of Appeals.
So they throw out the whole case against all the Oxford people.
The whole case against all the defendants. We have a federal case going, of course, as well.
Right.
But yeah, our state case would be done, and then it would be in the hands of the Michigan Court of Appeals.
Well, even more troubling, we've not troubling, but we've sued the Crumleys, so the case date won't be over.
Well, I totally forgot about that.
We won't be able to appeal at all. we could try to leave app.
We'll be forced to make a decision. We can try, but even
We've
if
done
we
this
try,
before, Chris.
Yeah, it's so frustrating, especially for victims, because what ends up happening while our appeal is up against the governmental defendant, we have to decide, do we want to continue the case against the Crumleys and maybe even have to go to trial against the Crumleys and the Crumleys
knowing
only?
full well that they don't have a pot to
Yeah,
pee in
and-
and have no money to pay anything.
Right. And what that ends up looking like for victims, and this is what I wish the Supreme Court would think about when they look at the court rules, is that means that someone like Keegan Gregory's family,
Right.
who Keegan Gregory went through horrific, he's one of the students who survived the shooting, but he witnessed horrific events that were very traumatic for him.
Justin Schilling was shot and killed right next
in
to
front of
Keegan
him.
Gregg, right in front of him. And then Crumley told Keegan to lie down next to Justin, and he knew he was dead. And luckily for Keegan and everyone, he ran, and I don't know how or why, but thank God Crumley never came after him and never even shot at him.
Yep.
But that poor young man is living with all of that on top of everything else.
And under the Supreme Court's rules, he could now have to testify twice.
Right.
He could have to testify at one trial against the Crumleys while the appeal is pending, and then come back and do it again when we win on appeal
Right.
in the other case.
Correct.
Can we
And
go-
so it's a
Can we go back, Chris? I just want to say, because I think the viewers would want to understand what you're saying is that the rule that says that the case has to be
Final.
finalized.
It's not final.
final order.
So you'd have
right?
to do an application for
Correct.
leave to appeal.
That's right.
So
And
just,
we usually get told no.
right.
Yeah.
So just so that the viewers understand, there's two ways to go to the Court of Appeals. It's by right and it's by application. The application would mean that it can be granted or maybe not granted. And as Ven just said, usually not granted.
And you usually don't find that out until a year later.
Right.
And so,
So you sit there waiting, and they go, "Oh, by the way, you've waited a year. No, we're not going to hear this. So you've wasted a year."
But the flip side is, if the government loses,
Thank you.
automatic,
Tell 'em, Paul.
automatic right to appeal, right?
So-
Chris?
yes, that's right.
Put everything on hold.
If Oxford's motion is denied, they have what Judge Krause was just describing. They have a right to appeal. They don't have to
Automatically.
file an application.
So then ask
They get
yourself,
to
how the
automatically
fuck
appeal.
do they have an automatic right of appeal in the middle of a case when in any other case, again, private school, and if the private school brought a motion for summary disposition, just argued this should be thrown out of court, and the judge said no, they don't have an automatic right of appeal, but since it's the government, they do.
Is that C7?
Yes.
Yeah. Okay.
Right.
then
And
they
but
did
by
the-
the way, do you know where this, and I actually, you're going to be proud of me. That's not a statute. That's the fucking
court
Supreme Court.
Yeah.
Court rule.
So it's a Michigan court rule, folks, and under Michigan law, the Michigan Supreme Court, they actually are responsible for making these rules and then literally signing off on them. This was a created rule in the middle of, Chris, the late 90s, early 2000s.
I'm not sure when the rule came
well,
about.
it was the Engler court, I can
Okay.
tell you that. And they came up with this to give government a leg up so they could get their case up on appeal. And what it ends up doing, just like it has in Flint water, even though it's a different type of case, like it is in
Midland.
the Midland
Man.
flood cases, we're on a fucking appeal for 2 years now because they file these motions right away, argue governmental immunity, even though those cases are inverse condemnation, and we won't go there, y'all, but it has nothing to do with tort or negligence. And they still say, oh yeah, Johnson's calling it inverse condemnation, but it really is tort. We've been on appeal now for 2 years up there on that, and that's what they were almost 5 years in Flint and the Flint water crisis, because they argued these fucking things, Amy, really just to kick the can down the road and stall.
Well, and then they come back, you do some discovery, they file a C10.
Right.
The
So
C10, the C10 gets denied.
and C10 means what, Paul?
Well, that's a motion for summary disposition claiming there's no factual dispute. So theoretically, it occurs after discovery is over.
Right.
No factual dispute, Judge, we should win. Judge says, no, I disagree. They take another automatic
So they
appeal.
get 2 bites at the same apple. And that's exactly what Mullins and Oxford did in this case. That's why we filed this case in January of 2022. They filed their first round of motions for summary disposition, they being Oxford, in March. And why did you do that? So they could stall for the next year and a half in the Court of Appeals, right? And then luckily Judge Trudeau said, bullshit, Johnson, go take your depositions, go do like any other case. So we got lucky. We had a phenomenal judge.
Which judge? I'm sorry.
That was Judge Rayleigh Chabot, who just retired in the last day of December this year. because she's a Republican and didn't want to, obviously, she filed the general rule of retiring at the end instead of giving the governor the automatic appointment. But she was phenomenal and allowed the case to materialize. And thanks to her, at least now some of the families have some insight of what the fuck really happened that day and who did what wrong. Because without that case, our case in general, by the way, in the federal case that Chris is talking about, where all the other plaintiff lawyers have filed their case, by the way, other than us, and now Todd Flood, he joined us as well. In state court, everybody else did the federal route because they're trying to get around governmental immunity, knowing how bad it is. Mm-hmm. And Judge Goldsmith, the federal judge, has not allowed any depositions except for one on the issue of insurance. So these families would not have gotten any of the police report, all of the police report, all the video, everything that you've now heard about in the media. That is through our lawsuit in state court.
What was the reasoning by Judge Goldsmith?
Because he's
letting them file their qualified immunity motion prior to discovery,
which is a federal governmental immunity issue.
When we prevail in that motion and the motion is denied, the Oxford defendants get to go to the Sixth Circuit Court of Appeals.
Right.
And then that case will stop for another 8 to 12 months during that process. And then they could take it to the United States Court of Appeals, or United States Supreme Court, depending on what happens there. So, yeah, we could be looking at years of delay before we have a federal deposition.
Oh.
Isn't that crazy?
Yeah,
I mean, it's a travesty. Talk about it.
I didn't know about that because I haven't done federal practice. I wasn't a federal judge ever, and that's a fascinating issue that
and it's totally
occurs.
Discretionary, right? He could allow depositions,
right.
and he just hasn't.
And
he's also, as part of his protective order, which I have to be careful of because we have a federal case as well. You got to be careful about, obviously, talking about the case to a certain degree.
Okay.
And that's why every time that I've interviewed or do press conference and so forth, I talk solely about the information that we have in the state law case.
Okay.
And to Judge Goldsmith's credit, he said, no, Johnson's got a case there. That's Judge Chabot's job, not mine. So he can go do it. But the point of the matter is that I think for the public, and this is where, I'm not a big believer in reading, all the comments and everything in terms of Facebook and our social media. But to be fair, and I'm guessing you all out there know this, when you have, Johnson Law has a social media page, of course, and Instagram and Facebook and so forth and so on. Part of the people that do the great job for us, and thank you, Near Perfect Media, and thank you, Seeds, but part of their job is to monitor the comments. And they actually can keep statistics on basically what's going on in terms of people and the percentages of support and so forth. And Oxford and us suing on behalf of the parents against the school, it's like 99.9%. And you get the occasional lunatic that wants to kill me because I'm suing a teacher. By the way, everyone, mom and dad were both public school teachers, so you're welcome. And they would be appalled by this conduct, by the way. But in any event, so this is, it's not a close issue, Amy, in terms of the court of public opinion. Mm-hmm. But think about this case, right? Not ever even going to trial, and where the parents can have the jury see all this information that the teachers had and didn't use or gave to certain people, and they didn't take the next step. I want to mention one other aspect, guys, on the gross negligence of the proximate cause. When we're talking about gross negligence of the proximate cause, in the majority, at least in the type of cases we're talking now, like for example, Oxford, we're not even including Oxford community schools. And this is kind of a lawyer in the weed stuff, so I'm apologizing in advance.
Okay.
But one of the horrors, literal horrors, in my opinion, of governmental immunity, it does not allow us to sue the entity. It makes us, by statute, by law, sue a governmental employee from that entity. So I want to sue Oxford Community Schools. Under governmental immunity, I can't, but I can sue their employees. But if I sue their employees, I can't just prove negligence and a proximate cause. I have to do that higher standard of gross negligence and the proximate cause. So we have a state law that actually forces me to file the lawsuit against the individual and not the entity. I think that's crazy.
Well, I have to say, I'm trying to figure this out because there are times that I would see lawsuits against Michigan State University and their employees.
So it all depends on what the facts are, right? If you have a set of facts that fall under one of the exceptions that apply to entities, then you can sue that entity.
Perfect example, like a police car.
Okay.
Police car, no lights, no sirens, and runs a red light. because it's a government vehicle exception to governmental immunity, I can sue the cop, or actually the city, not the cops, and the cop.
Okay, and so the same with the shootings.
But not in the shootings.
Not
I
in the
can't
shootings.
sue because it's not an exception.
There's no exception that applies to the school. So like when you've
All right.
seen cases against Michigan State, it's probably like a public building exception.
Right.
So that covers the entity.
Right.
But if you don't have an exception in the Governmental Tort Liability Act that applies to an entity, all you're left with is a gross negligence claim against an employee, and you can't sue the employer for that employee's gross negligence.
Perfect example. And I was reached out to by my former client, Karen. And Karen, I love you, and I think about you and Doug all the time. You remember the case, Chris. It was the dam, D-A-M, in Milford.
Oh, yeah.
Doug Killingbeck.
Doug Killingbeck, my very first case with you, actually.
And Doug was an incredible,
Kayaker.
but he wasn't right. He was doing like the Iron Man stuff.
Yeah.
Okay. But he would go out in his kayak and go, like paddle for 29 miles. He's one of those guys.
Wow.
So he was I forgot what's the park there.
It's Kensington Metro Park.
Right. So he got there, and then you get out of one side of the lake, and whatever you do when you carry your kayak and slide it down the little roller hill thing. And he saw two kids that were, I think, in canoes that they had gotten from a local library. And they were up by the dam, and they were getting close to the water thinking this is kind of cool. Well, for those that don't know, the water that comes out of these dams is like tens of thousands of pounds of pressure, and it is like a huge machine. You get anywhere near and it sucks you down and it kills you. So these two young men were drowning. Doug saw that and dove in after them. He saved one, and Doug died, and a young man died as part of that. The city of Milford owned this property, right? But it's a governmental entity. Amy, I couldn't fucking sue them.
Right.
And by the way, there had been multiple previous drownings
Right.
there in that same spot.
Right. I
Okay.
see what you're saying.
So in that case, because it's not a government vehicle, there's no other exception, I couldn't sue the entity.
Let me say this. I think that the reason that this just didn't come up in front of me very often.
Right.
Because it never got there.
Right?
Yeah.
I mean,
They don't get that.
They
yeah,
don't.
they just don't get there.
And here's the kicker. So when Karen Killingbeck came to me in our office, right, we had to have this conversation, Chris, I think you might have even been there, where you have to talk about, you can't sue. What do you mean you can't sue Milford? They're the ones that know about this. They've created it. And there's many different ways, by the way, of correcting that situation. So you don't need a 3-story waterfall in the middle of where everybody is kayaking, swimming, and having fun. Okay. But you can't sue them. So there were other entities in
a church group, and there was the canoe library itself. And
so there were other avenues, but it wasn't who really, in our opinion, should have been held responsible. And Karen just, she responded today. And again, Karen, I love you. She said, I know this firsthand, right? On the governmental immunity. She gave me a Facebook message because she saw a couple of the articles and stuff that we've been talking about in Oxford. But what folks don't understand, why Judge, here we have a former Court of Appeals judge on our panel, and she never saw cases like this because most lawyers won't even fucking take them, you guys.
That's it.
Because they go, Ven, you're crazy. Why would you take this on when you're probably going to lose? And the answer is, well, I'm not going to probably lose. And it's wrong.
And I got to tell you, I just cannot think. I'm literally sitting here now thinking of any case that I had that was just an employee that didn't involve Wayne State University, MSU, U of M, some other entity with the employee.
Right.
I am honestly sitting here thinking that I can't think of a case where that happened.
Isn't that crazy?
And it makes sense now why I never saw that, because
the law said you can't.
And and then one of the practical things that plays out, and we saw this in the Ray case, there are different insurance policies that cover the entities versus the employees.
Right.
You have
Right.
much lower coverage available to you when you're suing an employee than when you're suing Michigan State University.
so people don't want to take the cases.
Well, and it's affecting, how
mean,
much
I don't-
money
It affects
you'll
everything.
actually be
I don't
able
mean
to
it like
recover.
I don't mean that to be mean, but I mean
If there's no recovery, if there's no chance of a recovery, perfect example is us suing the Crumleys, right? Well, we sued them because they are clearly, all three of them, responsible in part for what happened on that day. So we sued them. We know full well they're not going to have an insurance policy that covers that, and we know they don't have a pot to pee in.
Right.
But yet we want to hold them, Paul,
Sure.
use the word full accountability.
Sure.
So we have them in. But we also have, and your point's well taken, Amy, that if in these situations, if a governmental employee doesn't have adequate insurance to cover him or her for what happened, then the government gets out for nothing. And it's just so inherently wrong and unfair. And that's not what the system is supposed to be. My deal is here. You're elevating government. You are elevating government above the people who put the government in place and pay for it.
Right, and governmental immunity was based on the king. I mean,
Say it.
I mean,
Say it, please.
okay.
Explain.
I mean,
what do you mean?
Okay, I'll say it as simply as I can. Governmental immunity is based on the fact that at one point there was a king, and the king had coffers, and the reality is coffers mean money, and the money had to be kept because it couldn't be wasted or given away. So the reason we have governmental immunity is because the king couldn't give away all of his money. And that's essentially where that comes from. And we don't have a king. I mean, at last I checked. So we
we voted him out. I think last time.
So we don't have a king. We've never had a king. We only have presidents, and they're not kings. And so that is from where it came.
Right? Common law, folks, from way back in jolly old England.
So I know that, and I didn't know that, and I haven't had any cases with individuals. Isn't that's just crazy?
If you folks listening or watching have not heard the podcast that we did with Lexi, L-E-X-I-Pew, P-E-W, hi Lexi, I love you. Lexi was also one of our clients who got completely screwed, fell out of a window at Michigan State University when the window wasn't adequately screwed in. So she leaned against a window just to sit back on a register on the 6th floor and fell and lived, by the way. And by the way, if you don't see Lexi, go on her Instagram page and watch how a young lady who shattered her leg and her hip has now taken up ballet. I mean, talk about a absolute stud. Got nothing. But we sued Michigan State. Why, Amy? Because of the exception. Public building exception. Oh, Chris, tell her.
It's enraging.
Chris, tell her.
So,
what?
Under the public building exception.
Case Hall? What was the hall?
Case Hall. It was
Okay.
the hall that I lived in. It was the 6th floor. I lived on the 4th floor. She was in a study lounge. She was visiting friends who were students there. She was a high school senior.
Yes.
She was visiting them within the rules of Michigan State. She had signed in as a guest. She had given them her ID. They let her in.
Right.
When she fell out of the window, it was sometime just after midnight. The building closes to people who are not registered guests at midnight. What the court said was that at the time that she fell, the building was no longer open to the general public. So it was not a public
So it's not
building.
public.
It's not a
A public building that was built with public funds isn't public when it's not officially open, even though she's lawfully on premises.
And registered.
Yes,
Yeah.
They still had her driver's license.
And it was open to registered guests after
It was.
midnight.
It was. There was no argument that she was anywhere in the building she wasn't permitted to be, that she wasn't allowed to be in. The argument was simply, sorry, had she fallen at 11:55 p.m., you'd have an argument. But
And real
because
quick-
she fell at 12:30 a.m., she does not.
Thank you, Andrea Sievers. Text me. Lexi's podcast episode of our Gloves Off, episode 5, if you want to check that out.
I will.
But so she falls, lives, thank God, horrible injuries, but lived, and ultimately thrown out by the trial judge. I'll never forget that because he just got on the bench and said it wasn't a public building. And then, because it was closed. And then the Court of Appeals said, we agree, affirmed him. And then we appealed to the Supremes, but that is not an appeal of right.
Yeah.
And it was an Engler court, and they wouldn't even hear the case.
Yeah, I think that was like 2014 or so. So it was before the Supreme Court had sort of shifted a little bit.
Well, I obviously was not on the Court of Appeals panel.
You were not.
You were not.
I'll tell you
I just thought
afterwards
I'd
who
mention.
was.
Well, let's just talk about a couple other cases that our office is handling, y'all, that we're going to be talking about coming up here. And yep, you're right. We're going to be talking about governmental immunity, each and every one. Paul, tell us real quick about the Goss, G-O-S-S case. Now, that is against the DNR, and explain why it is that we can sue the Michigan Department of Natural Resources, or really it's the state of Michigan, actually.
Well, Chris has mentioned there's a motor vehicle exception to governmental immunity. The issue in this case, the DNR officer was driving what's called a gator. It's a tracked vehicle. He's towing a grooming rake behind him. He's grooming a cross-country trail. The cross-country trail intersects with a snowmobile trail, which has no speed limit. Our client is coming down the snowmobile trail about 60 miles an hour, well within his rights. The DNR officer pulls in front of him, runs a stop sign, pulls in front of our client. There's a collision.
T-bone.
Massive explosion. Unfortunately, the DNR officer's killed, incinerated. Our client breaks half the bones in his body, burns
Burns off his hands.
his hands, just terrible injuries.
He was a master marksman, by the way, one of the top in the country.
Yep.
And this man is so incredible. Mark, we love you. And they've literally put his hands somewhat back together the best that they could. And how this man has just made, and he's in pain and it's constant surgeries. He just had another one, Paul.
Another surgery.
It's one of the worst damages case I've ever seen. And the state of Michigan, we're up and down the appellate chain, guys. Tell them.
Well, Chris, take the motor vehicle part of it.
Well, so initially the state's argument was, yeah, there's a motor vehicle exception, but a
So
gator,
I can sue the state.
but a gator's not a motor vehicle. This doesn't count as a motor vehicle.
I remember.
It went to
reading
the
this.
Supreme Court.
Right.
Yeah.
I remember reading this.
Yeah, so it went all the way through the Supreme Court. We finally we prevailed at the Supreme Court. The Supreme Court said this is a motor vehicle.
Because the Court of Appeals did not rule in your favor.
They did actually. So the Court of
they did.
Appeals
They
did
did
rule
it
in our
hard, but they
favor.
ruled against Marco, right, in his case, or no?
I think Marco won as well. So John
Okay.
Marco, who's another local attorney,
Great
he had a
lawyer.
case involving a snowmobile
Right.
as opposed to a gator.
That's
Right.
the one.
And
Right.
that one was published. Ours was unpublished. And
I think-
they were decided within a week of each other.
I might have been on the snowmobile.
on the
case.
snowmobile with Judge Stevens was on it. I know
think
Stevens was on it.
I think I might have been.
And so
I'm not sure, but
the state filed an app to the Supreme Court on both of those cases in
Okay.
combination. The Supreme Court granted oral argument on it, and we
That's it.
luckily prevailed. And then they did exactly what Paul was
So
talking
we
about.
come back to the Court of Claims.
Right.
We embark on a year of discovery, 35 depositions, all the investigating officers, et cetera, et cetera. They file a C-10 motion saying that there's no evidence that the DNR officer was negligent in his operation of the motor vehicle. Judge Gleicher writes a great opinion saying not only am I denying your motion, there is no other plausible explanation for how this happened other than your guy ran a stop sign into the path of the snowmobile operator. It's uniform among all the police, the experts, motion denied. So basically, without saying it, she granted summary disposition on liability. Well, guess what they've done? They've taken an appeal
Again.
of the C-10 denial.
So we're now going up the entire appellate chain twice. And by the way, we all love Judge Lisa Gleicher. She is amazing. She's chief of the Michigan Court of Appeals. She threw out our gross negligence case and said that you can't say that running a stop sign in the middle of the woods coming into a clear snowmobile path where there's no stop signs, obviously no signals, and there's no speed limit, you can't call that gross negligence. So she threw that out. And I just mentioned it not to bitch because I love Judge Gleiser. I don't agree with her on her conclusion, but the fact of the matter is it shows you how high gross negligence is. And let's be honest, we're suing an individual who and his wife, who's his widow. It's not a great look, but we're forced to do that. This is my point.
Right.
When you force us to sue the employee, because I now can't guarantee that my client wins on the government vehicle exception of
Right.
this gator. So I have to have a fallback. So I have to sue the individual, even though I don't want to sue some guy, even though it was his fault, who's dead, and
you
bring his wife, his widow. Last thing in the world I want to do. But I have to adequately represent our client.
Because the
And you-
three-year statute was about to run.
Right.
Now
I
the
waited until the 3 years.
You chose not to until you
Initially.
chose not to sue him initially
Right.
until the state made their argument that this isn't a motor vehicle.
So we were on appeal
And
when
so-
we didn't know which way they were going to rule, so we had to.
So it's again a situation where the state is basically forcing us to sue an individual as opposed to them.
Who works for them?
Right. Sue one of their
Right.
employees
It just
instead.
from a public policy standpoint, it makes no sense whatsoever. And
you think that the Attorney General understands
well, this
that
is
that's
what's
what's happening.
Thank you,
That's
Amy.
the other
And this
crazy
is the
part
next
is-
crazy. So in other words,
I
now
mean,
we're going
the Attorney General.
I've tried
represents-
to get Dana. I've literally written a letter, right?
Oh, have you?
And
Okay.
you get nowhere.
You think
And-
about a
but to be
business decision. What would be a rational? Let's call it a business decision. You've killed an employee. You've got a maimed member of the public who can't work, was making 100-something thousand a year, can't work, severe depression, PTSD, his body's broken, etc. Why don't you say, okay, we took our run at these people. We made them go through hundreds of thousands of dollars worth of discovery. We've had our fun. We need to resolve this now. We need to do the right thing and resolve it. So we're trying to facilitate this case. We get back the message. We don't care. We're not going to participate in settlement because
Didn't even offer anything.
nothing. Because even if we lose our C10, we're taking it up. So we're not even going to participate in settlement.
And this is what governmental immunity creates. It's created. The pendulum has swung so far to the right that it creates a situation where these entities, Oxford Community Schools, right, the Department of Natural Resources of the state of Michigan in this particular case, and we have other cases we could talk about, but it's created such they win all the time by motions and never have to go to trial, that they fucking do this, and they do it twice inside each case. So these cases, just like the Ray case, Chris, that Chris and I actually won in the Michigan Supreme Court on a the proximate cause issue. First plaintiff win since 1992 is what I know you told me.
That's right, yeah.
And we
Since
won
Day-Days versus Ash, which was in the early 90s, and then Robinson came out in 2000, and no plaintiff ever won
after
again
that,
since
until us.
Robinson.
Ray
Yeah.
versus Swagger, and that was
2017.
2017.
Came out.
And Ray versus Swagger, by the way, is not only our case, but it was against Tim Mullins, his firm, who represents Oxford Community Schools in this case, by the way. So we're going to be arguing about all of that in these motions that come up. But again, what it shows is they've won so much for so long that they literally have no incentive to do the right thing by their own constituents and simply pay for what they've done.
And to their own employees.
Right.
Well, it's like maybe they could save a little now versus a trial verdict. Why wouldn't you explore that possibility? When you have a case that's worth $15, $20, $25 million. Why not take a chance on maybe we can save $5 million?
Let me just add this. I was an assistant attorney general for 6 years
Right.
under Mr. Kelly and under Secretary Granholm. And, we were very busy. It's a very busy office.
No question.
I was
No
very,
question.
very busy. And I was in the criminal division, so I didn't ever handle any cases like this. But it's a very busy office. So you're right. Why wouldn't you try to work things out?
If it's inevitable, you're going to pay a lot of money.
Right, and particularly when you're ultimately going to have your employee who's dead be sued and
Right.
his wife be sued
And
as
drag
a
them in.
representative. I mean, that's just a horrible thing to do to your employee. So that doesn't make any to your deceased employee.
Right.
I mean, what a horrible thing to
It is.
do.
It's horrible. And last, real quick update on Midland flood. My mid-Michigan people, I love you and thank you for your patience, because you gotta feel like our government has abandoned you yet again. So we're now going on 2.5 years, guys. We're still fucking around on appeal. They've had 2 different rounds, and it's not even a tort case, Amy. So
No.
all they're trying to argue is that this is really a tort case. They just call it inverse condemnation. It's not a close call. And the state of Michigan should be sanctioned for taking this position. We've dismissed all other claims except for inverse condemnation, folks. It's fancy lawyer terms for the government steals takes your property and doesn't adequately compensate for you. So if they're putting the highway through your backyard, they got to pay you for taking
Right.
your property when they take it. So it has nothing to do with tort, but yet they're still claiming on appeal that that's really what it's all about. It's absolute frivolous.
And zero discovery.
Zero
2.5
discovery.
years in, we haven't gotten a single
not a
deposition.
single deposition
Why?
because we're stayed.
We're stayed. They get an automatic stay when they take up an appeal.
Right. Okay. So they've taken up an appeal.
And so
you
again,
stayed. Okay.
the state of Michigan and governmental employees, but these state institutions and local communities like counties, and they're doing it to the very people who pay for their services. And that's to me like when a prosecutor, I mean, this will be our last point. You know this because you were a prosecutor as well. When you're a prosecutor, you have a bigger duty than just to get convictions.
It's not the duty of the prosecutor
Thank
to
you.
get convictions. The prosecutor's duty is to do justice.
Right. And so as a state attorney general or an assistant attorney general, and you have these cases, you got to know that the enemy, the other side, are the folks that employ you. So there should be a different standard, if you will, and thinking, in my opinion, on these cases than what we currently have. And what they're all doing, and it's 100% clear, they're deny, defend, delay. and then they'll kick the can down the road, just like they did in Champaign, guys. And luckily, they actually paid right now instead of waiting to trial, because typically they would wait closer to trial. But look at all the things that we had to go through, like Paul mentioned and Chris mentioned, and it took that long on something that is so clear on a stupid notice defect issue, right? So, all right. Well, anyway, thanks to my guests, Paul and Chris and Amy especially. Thank you again for coming over. It's been great. And guys, you already know this. We ain't done talking about governmental immunity. So we're signing off with podcast Gloves Off, episode number 25. Stick with us. Plenty more, because Ari, my daughter, who runs all the show, she says I need to stop screwing around and start doing more of these. So I guess that means, guys, that's what we're going to be doing.
Got to do it.
All right. Have a great day. Happy New Year, everybody. Thanks for listening.